I commend this bill to the House.
The Honourable Phil Goff.
Mr Speaker, Labor will be supporting the Victims' Orders Against Violent Offenders Bill, but I've got to say we do so with some serious reservations, and Kate Wilkinson touched on one of them, and that was the issue of the threshold. Because when I read the Victims' Impact Statement, I read that this bill was motivated by the case of a young woman in Invercargill who found that the person who had been convicted of her rape had moved in next door to her. And everybody in this House would understand the absolute trauma that a rape victim would suffer confronting each day the person that had been responsible for her rape. And there was nothing that could be done in that case, apparently. And I thought, well, fair enough. The government has admitted they've got a gap in their system and they've moved to address it. And then I went back and I read the Southland Times. And what did the Southland Times say about the person that was convicted of the rape? The Southland Times said that person was sentenced to 4 years for the rape. Hang on, this bill in it says that this protection only applies if you've been sentenced to more than 5 years. So the very case that provoked this legislation would exclude the victim that the Minister was crying crocodile tears about, saying that there was no legislation to help her. Minister, there is still no legislation that would help her in that case. So well should Kate Wilkinson come into the House and say the threshold level might be too high. Absolutely. Victim support, the Shine organisation, Jane Drum, a person who's chief executive of that, worked in this field for a long time, said, why the hell is the government bringing in legislation that will deny the protection that they claim the legislation is about to so many of the people who are victims of that crime? Now, I don't want to respond to Kate Wilkinson's long litany of self-praise for what the government has done by saying the government's done everything wrong. You know, all governments, I hope, have a focus on the rights of victims and protecting the rights of victims. But I've got to say that there are some much more fundamental things that need to be done in this area than this scrappy little piece of legislation provides. I read, Kate Wilkinson and Chester Borrows, that in the impact report, regulatory impact statement, this will apply to 10 cases. 10 cases a year. Well, look, for each of those cases that might be important. I'm not knocking it solely on that basis, but what I am saying, don't come into the House full of self-praise about a piece of legislation that will help 10 victims when there are thousands of victims out there. And I want to go back to what Alfred Naro said in his speech on this bill, where he said, we're bringing down the crime rates. Well, I did a little bit of research, and members might be interested to know that in 2009, the Ministry of Women's Affairs reported on the whole issue of women who suffer from sexual violation. And what they said about that, they said only 9%, less than 1 in 10, of all sexual offences were ever reported to the police. 9%. Only 9% of all of those dreadful crimes against women were reported to the police, but it doesn't even end there. Of the 9% that are reported and are taken up to taken to the police, only 13% of those actually result in a conviction. So we're talking probably about 4 in 100 victims of sexual violation who achieve justice under our current system. And if the Minister was really serious about the question of sexual violation of women and how they can achieve justice and how they can be helped to recover from that, might like to consider a couple of things. And I say this in all genuineness. These are things that we need to consider. The first thing is our adversarial system helpful for the hearing of cases of sexual violation and sexual assault? And I'd put it to the House that most women, having been traumatised by sexual violation, don't want to be re-traumatised by having an adversarial system where their word is thrown into doubt. And when women were asked why they didn't report, because in most of these instances there is no independent witness. And they did not want to suffer the trauma of sexual violation only to go to court to be disbelieved as to whether they were making it up. Now, I'm not saying that people will never falsely report rape. Unfortunately, tragically, that happens. But in the vast majority of cases, women who have suffered that trauma will not see satisfaction through our adversarial system because they won't be believed, because they don't have independent witnesses. And so why would they go through that, as my colleague has just said? I want to talk about restorative justice, because Kate Wilkinson said more money's gone into restorative justice, and I truly welcome that. When I talked as Minister of Justice to a group of rape survivors, they said to me, you know, it's not about wanting to see the offender jailed for long periods of time. And I was quite astounded by this. These are people that were many times suffering from sexual violation of strangers, sometimes the so-called date rape, but it wasn't about revenge. The main thing they wanted an admission by the offender that he had offended against them. Surely that's not too much to ask. And they wanted to see remorse from the offender. And some of them said to me, and I was astounded by this and by their personal generosity, having been through that trauma, you know, we don't want to see that person locked up for 14 years in prison. We do want to see their admission publicly that they have wronged me, and we do want to see that they are remorseful about what they've done. So, you know, we are dealing with a piece of legislation in the House today that is about 10 of the thousands of people who are subject to sexual assault and violation. And maybe we should be looking, Minister, at something more fundamental than that, about how we can change the nature of the wider system to help prevent this sort of abuse and to deal with it in the majority of cases, not 5% of the cases. So I say that not judgmentally of the government, but as a genuine expression of the problem that we've got and the failure of the system to address that. Now, I want to come back to what's in the bill. The need for this bill is apparently because the person who was the victim, in this case, where the rapist moved in next door and changed the nature of her life, made it far harder for her to recover from the trauma she had originally suffered. A protection order doesn't help the victim in this case because she was not the subject of domestic violence. A restraining order would not help in this case because she was not the subject of further direct harassment by the offender. So there was a gap, and I accept that if there is a gap in the system, and I think the victim does have to come first. I listened carefully to David Clenton, and I think he was making some reasonable points in a reasonable way, but the victim must always be put first, Mr Chairman. Now, what we've got is a bill that we have real problems with and that I want to address in the Select Committee. The threshold is too high. 5 years would not have helped the victim that this legislation was purportedly about and wouldn't have helped hundreds of other victims who are automatically excluded. And I asked the government, where did this figure come from? Was it just arbitrarily plucked out of the air, or was it based on cost? And that's what I really fear. Well, if we limit to 10, it won't cost as much. I'm sorry, if the victims come first, cost is the secondary consideration. Secondly, there is a real concern about the time between the release of the offender and the acceptance of a non-contact application, and there should be the ability to apply for non-contact orders before the release of the offender so that the victim is not suffering from a long period of trauma until it's heard. That's a change that I think we should look at as well. Thirdly, I think Andrew Little is right. This places the burden on the victim both to take the initiative to seek the order and also to pay for it. And if we're trying to relieve the pressures on victims, don't put the costs on victims for what they are rightly entitled to. That's the third change we need to make. And the fourth change is the limited application that I mentioned before. 250 offenders a year are released on serious violent and sexual offences, and this will help just 10. So, OK, maybe there's a good intent here, but it doesn't make much difference. I think the Select Committee, Mr Speaker, has got a lot of work to do if we are truly to put the interests of victims first.
I call Katrina Shanks.
Thank you, Mr Speaker. It's my pleasure to take a